Okay, well, we're doing another quick video here for our class on the law, and this one here we'll talk a little bit about what we call Wickard versus Filburn. Hope you like my new little whiteboard. That is a pretty good idea. And so it's Wickard versus Filburn. You can find it on Google by going to Wickard versus Filburn at oyez.org, and that's O-Y-E-Z, and then the case height down here is 317 U.S. 111. It's a 1942 case. It's important when we look at these different cases to understand the times that the cases occurred in. In this particular case, this was just the beginning of World War II when this decision was rendered. And prior to World War II, there had been the Depression. So there was a lot of manipulating going on in our economy in an attempt to try to help everybody, lift everybody up. So what they did in this particular case, old Leroy, I think his name is, or Roscoe, my bad, Roscoe Filburn in Ohio wanted to grow more than 11 acres of wheat. And he said that, the 11 acres, that's fine, I'll sell that. But I'm going to grow some more acres, I'm going to feed to my animals, feed to my family, and so forth. Well, the court said in this particular case, no. 11 acres is 11 acres. If you want to use part of it for yourself, and sell the rest, or sell it all and then buy some back for yourself, which would be pretty foolish. Whatever you decide to do, you can only grow 11 acres of wheat. So one of the things we have to look at is the times, because as we're facing potential of war, we're trying to come out of this depression. The government has a big job to do to try to help everybody. We get into famine, lack of food for everybody, then they're trying to partial everything out, and so it's an issue of safety versus freedom. So the court said that, this is a matter that Congress can regulate because of the Commerce Clause, which is found in Section 3 of the Constitution of the United States, Article 3. And so that whole issue of interstate commerce has gone pretty far. I think that the creation of the 14th Amendment after the Civil War has something to do with that. And so although there is a 10th Amendment, the rights of the states have kind of been shrinking in this modern world because of the advent of the 14th Amendment. And so using the Commerce Clause through the 14th Amendment to apply it more directly to the people in the states. Another example is this Heart of Atlanta case, where there is a restaurant and a motel where a group of people are African American, not allowed to eat in that restaurant, but it is on a federal highway. So once again, the Commerce Clause was used to enforce the civil rights of these people, even though it was not what you would call state action. What they're saying is because of the Commerce Clause, they can get involved. So this is just one example. We'll look at some other things throughout this course in the area of eminent domain, where people can lose their houses to the government because of the need for here again, safety. Safety usually trumps freedom in most cases. And particularly right now, people don't understand or remember that in times of war, there is a higher focus on safety, and certain freedoms have to be sacrificed in exchange for safety. This is particularly true in times of war, like I said. So, look this over, look through the rest of the content in your textbook and respond to the discussion. Always let me know if you have questions or problems. RobDawalt@me.com, and I'll try to get back with you as quickly as I can. Thanks a lot for watching today. Good luck this week in our discussion boards and throughout the class. Thanks again.